stop what you're doing, because a legal move meant to protect Melania, Trump may have opened the door to the exact thing powerful public figures try hardest to avoid: sworn questioning with documents. And it's happening inside a real court process, not in a rumor mill, not in a some people say story. Here's the key point. This situation appears to be the result of a strategy choice, and now it's getting very hard to reverse. The moment this turned into a legal trap, this story starts with a familiar playbook. A journalist, Michael Wolff, receives a harsh legal threat, one of those letters that basically says, take it back, apologize, or we'll sue you into the ground. According to the legal filings described in the competitor script, the letter demanded major retractions tied to claims involving Melania Trump and references connected to Jeffrey Epstein. The threat wasn't small either. It was framed as a massive, high-dollar defamation fight. Most people in that position do one of two things. They either back down publicly or they go quiet and hope it blows over. But Wolff did something far more aggressive. Wolff's unexpected move. He sued first. Instead of waiting to be sued, he filed first, asking the court to rule on the dispute rather than letting it hang over him. And that's where the pressure shifts, because now the conflict isn't just social media noise. It becomes a structured legal fight with rules, deadlines, and procedures. In his filing, Wolff reportedly laid out the statements being challenged and argued why they should be protected, either because they're substantially true, fair reporting, or opinion protected under the Constitution. Then he went further. He described the legal threat as something critics often call a slap-style tactic, a lawsuit approach that, according to many legal analysts, can be used to intimidate critics with cost and stress, even if the claims are hard to win. That framing matters because it tells the judge this isn't just about reputation. This is about pressure. The decision that may have changed everything. Here's the turning point. Rather than keeping the dispute in New York State court, Melania Trump's side attempted to move it into federal court. On the surface, that can look smart. Federal court can feel more controlled. The rules can be different. Sometimes teams believe it gives them an advantage. And according to the competitor script, the case landed in front of a federal judge in Manhattan who was appointed by Donald Trump. If you're a legal team trying to get a friendlier forum, that sounds like a win. But in court, a win can come with a hidden price. Because federal court isn't a place you enter just by preference. To be there, you have to qualify. The federal court requirement that triggers the danger. One of the common reasons cases go to federal court is diversity jurisdiction. Here's the simple version. If the parties are citizens of different states, the case may be allowed in federal court. Wolff is based in New York. So for Melania Trump's team to keep it in federal court, they would need to show she is not a New York citizen for legal purposes, meaning her true residence in a legal sense is elsewhere. And that's where this becomes risky. Because once residency becomes a disputed issue, Wolff's attorneys can argue they're entitled to limited discovery focused only on that question. Not the whole case yet, just this. Where does she actually live? And in legal terms, that one question can open a lot of doors. Why limited discovery can still get very personal. Even if discovery is limited to residency, think about what residency touches. It can involve questions like, where do you spend most nights? Where is your main home? What address is used on tax filings? What documents show your day-to-day life is based in one state versus another. And because this kind of questioning can happen under oath, it raises the stakes. People can't casually guess or dodge in a deposition the way they might in public interviews. Now, to be very clear, none of this automatically proves wrongdoing by anyone. But it does create a situation where answers, documents, and timelines can be tested against each other. And that's what powerful families often try to avoid, because even small inconsistencies can turn into headlines. The New York versus Florida problem. The Trump family has long been linked publicly to Florida, especially Mar-a-Lago. But there has also been years of reporting suggesting Melania Trump spends significant time in New York. The competitor script also raises the point that their son, Barron Trump, is reportedly attending school in New York, something that could strengthen the argument that New York is a central base for the family's daily life. If Wolff's team argues there's a good faith reason to question the residency claim, the court process may allow targeted requests for evidence, like records that show patterns of living. Again, that doesn't mean any conclusion is already decided. It means the process creates a fact-checking machine. Can the judge just block it? Not so simple. Some viewers might assume a judge can simply protect a high-profile person from uncomfortable questions, but jurisdiction isn't like a normal courtroom disagreement. Courts have to confirm they have legal authority to hear the case. If that authority depends on residency, judges typically have to allow enough information to resolve it fairly. So even if a court wants to keep things narrow, it may still have to let both sides gather what's necessary to prove or challenge the federal court requirement. The defamation claims and why the risk may outweigh the reward, the competitor script argues that the underlying defamation claims are weak because the disputed statements are described as either protected opinion, fair comment, or based on reporting that the journalist believes can be supported. And if that's the case, Melania Trump could face the worst of both worlds: a difficult defamation case to win, plus a discovery process that brings personal details into the court record. That is why critics of aggressive defamation threats often say, be careful what you ask for, because the courtroom demands receipts. The bigger story, how legal threats can backfire, zoom out, and this isn't only about one person. It's about a pattern the public has seen again and again. A powerful figure threatens overwhelming legal action to silence criticism. Then someone refuses to fold, and suddenly the threat doesn't silence the story. It legally locks the story into filings, motions, and sworn testimony. That's why this case matters beyond celebrity headlines. If the process continues, it becomes an example of something rare: a legal confrontation where the pressure tactic doesn't end the conversation. It forces it into a system that requires evidence. So what happens next? Melania Trump's team may have options, but none are clean. They could try to return the case to state court, though that might look like retreat. They could try to resolve the dispute early, if the other side is willing, or they could fight the jurisdiction issue head-on and accept the discovery that comes with it. But if the federal court path continues, the central question becomes unavoidable. Will this strategy force sworn answers and documents onto the record, simply to prove where Melania Trump legally resides? And here's the part you should be watching closely. If depositions happen, what questions will be allowed, and what records will each side try to use to support their story? Because once sworn testimony begins, this stops being political theater. It becomes a paper trail. So the real cliffhanger is this: does this case quietly get steered away from discovery, or are we about to see a high-profile legal fight where the most private details become the most important evidence?